we'll go through, we'll be able to finish chapter 8 today and Tuesday and focus on that. I thought that the review session we did last time, the evening before the test, worked pretty well, so I'll do the same thing. So next Wednesday night at say 8 o'clock again, I'll have a Zoom review session where we'll go through things. I'll sort of go through the main issues we talked about as well as a number of questions and then take all your questions. You can plan this week. So, in the interest of starting to get ready for the exam next week, you should know these questions. We've gone through them a couple times, but it's important. But the first question is simply ask. Courts which have the authority to review a decision from a lower court are said to have what type of jurisdiction? It's appellate jurisdiction. So it's either original or trial jurisdiction, but I call it, most of the people refer to original jurisdiction, which means you can have a trial. You're the original court that will make a decision in a particular case, but the appellate jurisdiction is that you can review what happened at a lower court. And so most of in fact, on our list of the six tiers of the federal and state system, all of those courts, right, that I put on that particular slide have appellate jurisdiction. They can hear decisions from lower courts. Only 3 have original jurisdiction. We'll talk about those. Which courtroom work group has the responsibility of demonstrating that the defendant is guilty beyond a reasonable doubt? It's an easy question, right? So it's either defense or prosecution. Prosecution, of course, that's their responsibility, is to prove guilt beyond a reasonable doubt. Put together all the evidence. We'll talk about a trial and putting together a trial and how they do that. In which court would a felony trial be held in the federal court system? What's the trial court of the federal system?
District court.
Yes, United States District Court to hear trials. So it's sort of the parallel of the state court to a trial court of general jurisdiction. Prosecutors present cases in federal courts just like local prosecutors do. What's the judicial selection method that combines appointment and election, right? So we have nonpartisan and partisan elections. We have gubernatorial appointments. And then we have what method combines the gubernatorial appointment and election. I know you know, you just want to talk. It's a merit selection, right? It's a merit selection of judges. This last issue is important because we ended with this. And so thinking about going back, thinking about plea bargaining, we talked about 4 things we bargain over. Bargain over charges, we bargain over counts, we bargain over charge types, and then we bargain over sentence. Those are the 4 critical things that are sort of on the table that can talk about. An important part of that is which is of those 4 things, charges, right? Charges, counts, charge type, and sentence, which is the most important. Sounds like a test question, perfect test. Anyone want to get it? Sentence, right? All those things point to the whole importance of the sentence. Changing target over all those things. The idea, why would you want to give up your right to trial? Why do you want to give your right to question the prosecutor's case? It's because you're getting something in return. And the most important thing that you get in return is a reduction in sentence, a better deal, if you will. So if you reduce counts, right, you're going to reduce your sentence. You're not pleading to as many counts. If you change the charge, it's making it less of a charge. You're going to a less serious charge, from a more serious charge. So you're bringing down the sentence. right? Charge type sometimes reduces the sentence, but that happens for another reason. But the most important thing is just everybody wants a better deal. They want less of a sentence. All right. So as I mentioned, our test is next week. Last night, or sometime yesterday, I posted there's a review sheet, a study guide. You can following through, start filling out the information that you need to know. There's less information, but I think in this particular test, but more specific types of information, both in terms of cases as well as some of the things we'll be talking about. Today and Tuesday, we're going to talk about the court process. You're familiar with it. We talked about this the second week of class. All the different decision steps that occur in court. We'll just put a little bit more context and talk about them in a little bit more detail, but they should be familiar as we talk about them. Just as a reminder, we talked last week about sort of the two different academic views about whether or not our court system is adversarial, which it's structured to be, or it's more administrative or non-adversarial. And there is different types of examples, important examples that kind of are used to show both perspectives. And so we talked about the adversarial process is that really the goal of both parties is to win. And so you have this sort of competitive spirit between both of them. They'll do whatever it takes to win. And anything less than a win is considered a loss, which is quite important from the attorney's perspective. And then when we'll talk about motion hearings, maybe today, but certainly on Tuesday if you don't, these are really where you'll see the adversarial nature of court, because you're really trying to get the best deal for your client, in that you're trying to get evidence taken off so that the prosecution can't use it. You're trying to get a confession thrown out. You're trying to get more time. You're trying to discredit a witness, whatever it might be. That happens prior to trial in these motion hearings. And if you look at a motion hearings, they're really critical. And so prosecutors put everything into those motion hearings because they don't want to lose that piece of evidence, and defense does the same. And so you see the adversarial nature. But then we also show and talk about how plea bargaining 90% of cases, sometimes 99% of cases in some jurisdictions, never even go to trial, that there's an agreement between defense, there's an agreement between the prosecutor and the client accepts it, the defendant accepts it in that particular case. And in these cases where defense attorneys are supposed to represent you or supposed to represent the client, they're more concerned with efficiency rather than protecting the rights of the individual. I spent just a second at the very end of class talking about these two cases, but they're important that you know them. And remember, Boykin versus Alabama. And so one of the things that has to happen, if you say I'm accepting a plea bargain, if you're giving up your right, because again, research shows that even if a person is innocent, right, they didn't do it. They will accept the plea because the risk of going to trial is too great, all right? They make a calculated decision, right? They weigh the costs and benefits, and they give up their right to trial because if they end up going to trial and lose, they're looking at a significant period of incarceration. Whereas if they accept a plea, they get a short sentence, or they may get a community-based sentence. So even though they know they're innocent, right, they can't prove the fact that they're innocent, right? And so they accept the plea where they're innocent. What Boykin does, though, is make you go before a judge and admit that you're accepting the plea voluntarily. You are not being pressured to accept the plea, right? And so you have to go into court and tell the judge specifically what you did, right? And why you did it. And so you have to make an allocution of what actually occurred. And it has to be voluntary. You can't be pressured to do so. And so the judge will say and ask you, are you doing this voluntarily? Boykin requires it. And then in Rickens, it says you can't change your mind, essentially. Right? You have to keep your side of the bargain in terms of talking about things. Because if you start backtracking, start changing your mind, then the plea will be thrown out, and then they'll reschedule and move the case back to trial or put it on the trial calendar. All right, questions about any of that? All right. I don't know, take a second and get this into your notes. It's really important to know, again, remember this process that we've already talked about. You'll need to know the order of these steps, all right? The exact order, so you know when, because they happen in a specific order for a reason, right? You cannot get to an arraignment without getting first either a preliminary hearing or a grand jury hearing, all right? You can't get to a trial with all the other steps unoccurring. So those things have to happen in a specific manner. There's also a number of steps we'll talk about regarding the trial, all right? In terms of the order that things happen in trial is very specific. We will go through those steps and you will have to know the order of those steps. It's relatively straightforward, but it's important to know. So know the steps of this process in terms of how they go. You'll have to know the decisions. Again, we talked about this earlier in the semester, but you have to know the decisions that occur at each step, and then who makes the important decisions. Right? Some of this should all be familiar to you as we talked about it, but we'll talk in great more detail at each of these steps. So we're essentially going to walk a case from arrest after the police's job is essentially done for the time being, and then walking them through the beginning of the court process all the way through the appellate decisions that occur. I'll put this up several times, but and go back to it. All right, let's get into the court. So you're arrested. Police officers arrest you based on probable cause. Within 24 hours, you have to appear before a judge at their initial appearance, and these are the critical decisions that are made. First, you'll be informed of why you were arrested. Again, you may have been told this when police officers arrested you, but they don't have to. And so you'll be informed of why you were arrested. You will again be informed of your constitutional rights. This is Miranda. You have the right to remain silent, remain all those sorts of things, but also that you have a right to an attorney throughout this process. And if you can't afford one, you will ask for one. This is where, remember, we talked about public defense, we talked about assigned counsel, we talked about private agencies taking on the public defense for a particular county. Depending on the county, you'll be assigned your attorney at this particular early stage in the process. Ask for it. So if you're entitled to one, if you don't have funds, if you're indigent, if you're too poor, you'll be given an attorney at this particular point in time. And the most important decision, at least from the defendant's perspective, is the bail or jail decision. About half of the people who are arrested are detained pending the outcome of their case. And so if you're arrested and then you are not granted bail, it means you sit in jail until your case is resolved. And even if you go to trial 6 months down the road and you're found not guilty, you still will have served 6 months within jail for that period of time. And so it's a really critical decision for a defendant for a number of reasons. The reason why, or the objectives of bail, there's a number of important objectives. From the court's perspective, the most important thing is to make sure that they show back up for all the different steps of the trial process, so that you reappear. That is, we don't want you to leave, right? Go out of the court today and say, yes, I'll come back to my trial, and skip town, right? Go to another jurisdiction, leave the country, or any of those sorts of things. The courts want you to show up. And as you'll see, that the court process lasts typically about 6 to 8 months at least, depending on the seriousness of the case. But you have about an 8-month period of time. And so during that 8-month period of time, you have to make, if you're the client, you have to go back to court several times. You have to go back for your preliminary hearing. You have to go back for your arraignment. You have to go back for motion hearings. You have to go back for trial. And so the court wants you at all of those or needs you there. And if you're not there, the warrant will be issued for your arrest. Now,
If you go to a bill, you work.
yeah, you do everything. There may be restrictions, so the judge can put additional restrictions, but they generally don't. But you can work, you can go to class, you can do whatever you have to do, be with your family, you can go about your life, but there's certain things you can't do. You can leave the jurisdiction, those sorts of things. And the judge might say, if they're concerned about, if you're a flight risk, they might have you surrender your passport. They might have you check in with the court every single day, something like that. But rarely do those things happen. You can do whatever you are, just like you're free and not part of the court process. All right, so the first objective is to make sure you reappear at court. The second objective of bail is prevent somebody from suffering incarceration. Remember, the person has not been found guilty of anything at this particular point. And so the idea of bail is that we should not punish them. But bail should not be punishment. We shouldn't bail. We can't punish somebody until they're out. And so we should release them. We should side on the idea that they should go back to their lives. They should try to do whatever they want to do in their lives. And then if they're found guilty, that's when we worry about the punishment part of the system, which we talked about in the last section of the class. The third objective, and this is the objective that's relatively new to the whole decision-making process of judges. The third objective is to keep the community safe. Keep the community safe. An important case in 1987, the United States versus Salerno, right? The defendant in this particular case was denied bail, and the judge said, I'm doing it, I'm not allowing you to go because I'm afraid that you'll commit more serious crimes. Salerno was a violent, organized crime murderer. And so the judge said, didn't think about whether or not it was a flight risk, didn't think anything about punishment, just said, look, I want to make sure that you don't do anything, you don't do any more violence, so I am not, you have no right to bail in this court. And so it's essentially eliminated the constitutional right to bail in this particular case. So the Supreme Court eventually heard that case and said it's okay. That is, the defendant has no constitutional right to bail, and it creates this sort of public safety aspect of thinking about the bail process. So judges think about their decision is based on, well, I want to give bail at an amount so that this person shows up in court. I don't want to punish them, but I also got to keep the community safe, which is, again, a pretty difficult balancing act that they have to do. Which leads us to different types of bail. Most common use is this release, something called ROR, release on recognizance. Essentially what you're asked to do is sign a piece of paper saying, I'm going to show up at court when I'm supposed to. I'm going to look at my trial dates, I'm going to look at my court dates, and I'm going to show up. All right? So you sign a piece of paper, there's nothing that is exchanged, there's nothing that holds it to except your signature saying that I'm going to show up. All right, so all it is a signature. If you don't show up, a warrant will be issued for your arrest. When you're brought back to court, the judge is probably not going to give you a release on recognizance again. They'll either detain you pending the rest of your case or put some monetary bail. But the most common way, because most crimes aren't serious. Remember, the vast majority of cases processed by our court system are less serious crimes, misdemeanors, right? Person's usually just released immediately with their promise that they're going to show up when they're supposed to show up. There's other types of bail. Third-party release, you can think about this as sort of mostly used in juvenile cases where you're released to your parents or a parent or your guardian. And then the guardian does play some responsibility of making sure that that particular person comes to all of their trials. So if an 11-year-old's arrested, right? Part of the release decision will be a promise by the parents or the caregiver that that the juvenile will show up at court. So the release for the third party in that particular individual bears some responsibility to make sure that their daughter, their son gets back to court when they're supposed to. This is the question that related to the question that Miles asked in terms of conditional release. Judges can put whatever conditions they want that will ensure a person's release. So they can say, I will release you under promise that you'll appear, but you have to be at your house. You can't leave your house. You're on house arrest until your trial is resolved. All right. Or I'll release you, but you have to go give a urine sample once a week to make sure you're not using drugs. Whatever the judge wants to do, he or she can do. Right.
So part of what this says, let's say the parents neglect to bring a child back to court. Do the parents also receive some sort of punishment?
They could. So as part of their promise, a judge could punish the parents. And so if they're, I think the more important question will be whether or not the parent is making an effort to make sure they don't, or whether or not the kid just ran away and they're like, we tried, we can't find, those sorts of things. So they could be punished for it and charged if they're aiding in that. And sometimes, that's why sometimes parents won't take the responsibility or third parties won't. So conditions are just adding things. So this is where more common types of bail. So fully secured is monetary bail, right? And so usually when you think about bail, especially in high profile cases, they set a large amount, $500,000, $1 million, $4 million, $40,000, okay? And so the judge can say, look, remember what the judge is thinking. I gotta make sure this person shows up at court. I can't punish them. I gotta keep the community safe. So with those three objectives in mind, they look at a serious felon who's in their court. They can detain that person, right? They can say, look, there's no bail. But in general, the court prefers to release people because of the cost of doing it. And they have to set an amount so that it ensures that they come back. And so for a serious violent felon, you're gonna put a large amount, $50,000, $60,000, $70,000, and that is your bail, right? And so if you can come up and fully secured bail means just that. It means that if you want to be released and the bail is $50,000, you have to go up with $50,000. All right. And if you don't show up, you lose the $50,000. The idea of it is essentially you pay for not showing up when you're supposed to. Most people don't have $50,000 in their bank account. Most people don't have $50,000 in their wallet in order to do that. And courts recognize that. And so what they've done is then again try to balance it. They set the amount at a particular amount, but only require you to come up with a percentage of the total amount. So it's usually 10% of the total. So again, if it's just a $5,000, if it's a $50,000 bail, right, then you only have to come up with 10% of that total, and then you're released. If you don't show up, if you abscond, if you try to get away, try to jump, go to another country, then you're liable for the full amount. You're liable for the full $50,000. So the percentage bail is usually about a 10% amount. Again, 10% of $50,000 for a lot of people is a lot of money. They don't have that money in order to put up with it. They can't put that money together. They can't get friends and family to sort of cover that because, again, the friends and family have to be part of that and they're afraid of losing that money as well. So if an individual can't put up even the 10%, another option is to go privately secured. That is, somebody is willing to pay and take the risk for you. And so you go to a company, you've probably seen signs for bail bonds companies. those companies will cover your bail, right? And so you go to court, $50,000 bail, you can't afford the 10%, you'll reach out to the bail bonds company, they will cover that amount with the court, and then they are responsible, right? They are responsible for the full amount if you don't show up, right? So that's a big risk. And so they are motivated, highly motivated to make sure you show up at court. And if you don't show up at court when you're supposed to show up at court, right, they go out and find you, or they try to go find you, right? You may have seen, bounty hunters. There's a number of shows where they do this. This is, I think, Dog, the bounty hunter, where, his job is to, people who have skipped bail, and goes and finds them. So he's hired, they're either private contractors where they work for a particular bail bonds company to go and track down people who don't show up, so that that bond company is not responsible for what is owed to the court. So the bonds company is taking some risk, and so they're highly motivated to make sure you show up. The interesting thing about people who chase down, they really, if you skip bail, all the things we talked about regarding rights, if you skip bail, you've pretty much thrown out all of your constitutional rights. Okay? Bounty hunters really have very few limits about what they can do to bring you back to court, because you have violated the court's trust by not showing up. And so a bounty hunter can, without a Fourth Amendment concern, break into your house in the middle of the night, while you're sleeping there, and tie you up, all right, throw you in the trunk of their car, and drive you back to court. That is not a violation of anything. They pretty much have uninhibited opportunity to do pretty much whatever they want to make sure you get back. All right. The last type of bail is unsecured. Again, most jurisdictions use some form of monetary bail and some formula through these four different things. Fully secured, because the full amount, this is 10%, this is 10% paid by bail bonds. Unsecured is the full amount, but you don't have to come up with anything. But if you don't show up, you're responsible for the full amount. So $50,000 unsecured bail means you can go home. Show up your court overtime, doesn't matter. So if you don't show up and a warrant is issued, then there's some responsibility to pay a monetary fine because of that. All right, questions about bail? At least these different types of bail. All right. All right, let me ask you a question. Think about this as a judge. Put yourself in the, behind the bench, and you're the one that has to make this decision. Remember the objectives of bail, right? You have to make sure that this person shows up at court. You have to make sure that you don't punish them, but you also have to protect the community. So, based on that, what do you want to know about them? How do you make an informed decision about whether or not this person should be given bail, the right to be released, and then what the amount is? Good. Have they offended in the past? Do they have a criminal history? All right, good. What else? Good.
Are they any sort of drug addict?
All right, whether or not they have any drug problem, whether or not they're using, what's the nature of that drug problem? What else? Good. Absolutely. All these are really important questions. Transportation, right? Do they have stability in their residence? And do they have a place to stay? These are all really important questions. Look, all of you, I suspect, have a telephone, right? Well, not everybody has a telephone. Again, the technological limitation. How do you get informed whether or not your court hearings change all the time? the dates change for a variety of different reasons. If it ever had gone through a court process, it may change a half a dozen times. It gets removed. Who's responsible for telling you that? Well, if you don't have a phone, if you don't have access to a phone, or if your phone changes frequently, like getting that information is difficult. So oftentimes, when a warrant is issued for somebody, they don't show up. The reason why they don't show up is they didn't know the court changed the hearing date. And so they're surprised, they're like, they get arrested, they get pulled over for a traffic stop, and they find out they have a warrant issued for their arrest. Like, what do you mean? Well, you didn't show up at court. And they're like, well, last I heard, my court hearing was a month from now. How did it change? How did that not impact? So they don't have that information. All these sorts of things. And so what judges try to do in thinking about it is they think about where they're staying. They think about their community ties. If they have a job, if they're working, right? If they have a family, they're more likely to be motivated to stay. If they have, their residents, they don't have a place to stay, right? They don't have any other links to the community. Well, they may be more prone to leave the community, right? So if they have a job, family, and then of course, always legal variables matter too. The seriousness of it. Look, the judge does not want to be the person that releases a violent offender back to the community, and then that person does another crime when they're released. So you can see, just think of, again, put on the hat of a judge in a case like this. This is pretty straightforward, right? So an 18-year-old girl is arrested for shoplifting. She claims to be indigent. She had no steady source of income. She lived with an unemployed boyfriend, and she dropped out of school and left the trade. She had one prior arrest for shoplifting charges were dismissed. All right. So is this person that, as a judge, you could think about giving a bail and release, right? It's not a very serious crime, but all the other parts of her life would raise concerns for a judge, right? She doesn't have a stable employment. She doesn't have a stable living situation. All right. She has some prior arrest charges. And so in this particular case, the judge weighed all those things. And even though it is a really minor offense, shoplifting, relative to all the other things, the judge denied bail in this particular case because of the fear of a flight risk that she wouldn't show up. Also probably don't mess it. This is the other extreme. So again, you sit in the bench. Frank Wallace appears as prior convictions for rape and assault. He was arrested for robbery, but released on bail the first time. A 7-year-old man who was cooperating with the police was beaten and told if he testified he'd be killed. Right? The man went to the police and Wallace was arrested again. So on the second time, this is an easy decision for most people, right? This is an easy, let's detain this individual. Let's not give them, this person shouldn't be back out in the community simply because, number one, serious offense, serious offender, as well as intimidating witnesses, threatening witnesses. That's an easy decision. Again, this is a Chicago case. The judge flipped and released again in this particular case. Released, and then he went back and he did kill the witness in the particular case. Made the judge, of course, look terrible. The system looked terrible. It really was an odd decision. But people would say that, remember, that the purpose of bail is not to punish a person, right? They haven't been convicted of anything. And so the judge has to weigh those sorts of things. All right, problems with bail. There's tons of problems, both in terms of how it's used, who doesn't have access, if you're being punished, and that 6 months, 8 months, all that time you spent is a punishment essentially because you're incarcerated for a period of time, and so no matter what happens in your case, including a release, you would just have spent time. It does usually credits to if you get convicted. So if you spend 6 to 8 months in jail awaiting the outcome of your case, the judge will apply that time. If you're sentenced to 2 years, they'll take that 8 months and apply it to your sentence. But it is in fact punishment. So there's been a movement across the country to try to change the nature of bail, focusing primarily on increasing the use of release on recognizance, that people just show up, as well as trying to guide judicial discretion a bit. Two important things you both talked about. This is a seminal study on bail. The Manhattan Bail Project study is where they looked at the different outcomes, right? This is, again, we've talked a little bit about evidence-based practices and the importance of thinking about, whether or not particular decisions matter and how those decisions matter. And so essentially what this study did was looked at people who were released under all those different types, right? And compared whether or not they showed up at court and what they did while they were released. And so some portion of the people out of the Manhattan courts were released on the recognizance. Some portion of them were released on regular bail, fully secured bail, all the different types of bail that I talked about. And what they, at the end of the day, what that research shows is that it doesn't really matter. That is, putting somebody on bail on their own recognizance, on their promise that they'll show up, is as effective to making sure they show up in court as any other type of bail. And it is no more likely, a person who's put on bail for release on recognizance is no more likely to commit more offenses while they're released than somebody who's put on some other type of bail. And so why put the financial burden of bail as part of it? Essentially, that's the key finding from the Manhattan Bail Project, is that if all else being equal, is that all those different types that we talked about, that not putting the financial burden on a particular individual is as effective as putting it in, why not put the financial burden on it? And so with this particular study, the use of release on recognizance increased pretty dramatically. This project did a lot of different things in terms of trying to make bail more fair and more just. It did create a number of pretrial services programs. This is just, remember, this is the very beginning parts of the system. Usually, services programs in the court system happen at the end after we find them person guilty. But in this particular case, pretrial services programs really try to think through an individual and think through their ability to show up at court and what resources can make it happen. So if somebody was to come through and say, well, I don't have a phone, I don't have a phone number, that's easy. How do I find out whether or not my court can change? So they'll work with that particular individual to figure out some way to make sure that they're able to figure out when they show up and when they show up, and provide other types of services. The other important thing it did was emphasize the importance of giving some kind of guidelines, some guidance to judges about how to weigh different factors. So here, essentially what most judges look at when they make a bail decision is they'll look at a grid. And on the grid will be characteristics of the offense, whether or not it's serious and how serious it is, as well as characteristics of the offender. And then what that grid represents is their risk, the relative risk of whether or not a person is likely to show up at court and also reoffend while they're out in the community prior to the conclusion of their trial. And so judges weigh that evidence, that information that they have, and then they check off a box saying, look, this person has no risk or very little risk. They're going to show up and they're not a risk to the community. Whereas if they have some risk, they may either increase the amount of bail that they have or just deny bail. The 1984 Bail Reform Act is a really kind of foundational change in how we manage bail in the U.S. For a lot of different reasons, it really sort of forced judges to use guidelines, but it also, one of the things it did was create this public safety aspect of bail. That was new. Up until 1984, defendants, the notion of person's safety risk was not part of the jail decision. Afterwards, it was. Any questions? This is a really busy slide, but you can see kind of, instead of giving judges discretion to pick an amount out of the air, in terms of how much monetary bail should be, you can see the amounts and how they correspond for different types of crimes. I chose the pages that, you know, are the more serious crimes. So these are high-end sorts of crimes. And so you start murder, both different types of murders are really set by judges depending on the circumstances. But then you can see like kidnapping for ransom, kidnapping for commission. You know, the bail guideline is $1 million, right? In terms of, and whether or not you want to use a fully secured or percentage bail will be up to the judges, but you can fully secure $1 million. Some people have that, the vast majority of people don't. But you can see robberies are serious, and so $100,000 in order to be released. So in general, the bail guidelines take the more serious the offense, the more likely you are to require monetary bail, and the more likely that the amount is higher than less serious offenses. And so this ties with the notion that if you commit a serious crime, you're likely to spend most of the time in jail pending the outcome of your case. All right, any questions about bail? All right, so we get into the court system with bail, right? So remember, police officer arrests, they go to booking. Within 24 hours, they have to appear before a judge. Judge makes the bail or jail decision. A couple other things happen. You get your attorney at that time. That's within 24 to 48 hours of arrest. The other thing that happens within 24 to 48 hours of arrest is the informal charge decision. Informal charge decision, in about 50% of the cases, prosecutors decide not to charge the individual that has been arrested. 50% of the time. At this very first step of the system, prosecutors decide to kick the case out of the system. And so the individual doesn't have to go through the rest of it, 50% of the time. 1 in 2 cases, prosecutors say, I'm not prosecuting this particular case. Primary reason for that, remember the difference. There's an evidentiary difference. Police's evidentiary decision-making is based on probable cause, which is not guilt beyond a reasonable doubt, which is the prosecutor. And so police officers make an arrest based on, you know, their best guess. That's what probable cause is. Beyond a reasonable doubt is just that. You have to convince 12 people that this person did it without any doubt, and they will talk about what doubt means. And so if there's any shred of doubt, a prosecutor should decide not to take the case yet and push it out of the system. Because all these other steps, really, if a prosecutor charges you, then you have to find an attorney or get appointed to an attorney. You have to bear the costs of that. You have to show up at court at all those different steps. Your life changes pretty dramatically. And so what the court system is set up to do is kick you out of the system before you get into the rest of the system. And so the decision to charge is made by prosecutors. Prosecutors can choose. This particular decision, remember, it's 50% of the time. This particular decision is the only decision that we've talked about all semester that is unreviewable. All right? That is, the prosecutor at this particular step in the process has ultimate authority to decide to do with the case. If the prosecutor decides not to charge you, even if the prosecutor can prove guilt beyond a reasonable doubt, a prosecutor can say, I'm not going to pay for this case. I'm not going to take this case to the rest of the system. And if they decide to do that, right, there's nobody to review it. There's not a judge that can review it. There's not a police officer that can review it or anything. The case is over, or it's at least over for the immediate time. So prosecutors have that much power to decide whether or not, even if a person is guilty, they can decide not to charge a particular individual. Again, there's a couple of factors that are really important within a prosecutor's decision. Again, seriousness matters, right? Prosecutors are going to look really closely at a serious crime. And they're going to side with, even with weaker evidence, probably, they're going to side with charging a particular individual because it's a serious crime. Less serious crimes, the impact on the community is less. The other thing is community response, right? In terms of how the community may look at whether or not a prosecutor decides to charge or not to charge. You know, if a case gets a lot of publicity, a prosecutor may think everybody's watching, so they may be more prone to take a case, even though they may not have great evidence, or they may be prone not to take a case because of fear of what the community thinks. Remember, prosecutors are elected officials, and there's some costs there if they make mistakes. And when everybody's watching, prosecutors don't want to make mistakes like that. And so, of course, characteristics of the defendant matter, characteristics of the case matter, and so also community input matters. One thing prosecutors do, is most of the crimes that they come across their desk aren't serious crimes, right? So again, they're primarily concerned about the most serious things that happen in their jurisdiction, but you still don't want less serious crimes, to go unnoticed. So what prosecutors and what courts have done is create a lot of alternatives to even charging them, right? And so if you went through the system with juveniles, for example, they'll often have diversionary programs that prosecutors say, look, this is a first-time offender, this isn't a serious offense, we're going to ask you to do 25 hours of community service. If you do those 25 hours of community service, go pick up trash along the highway, do whatever it is. After you do that, you get a sign-off on that, we'll drop the charges as if they have never happened, go on with your life, don't come back in court again. If you do, then we're going to treat it a little bit differently. So those types of options, diversionary options, makes the public feel good because the person's not getting off with nothing. They still have to do something, but it also doesn't carry the stigma of having a conviction near the end. In Michigan, for example, there's a number of programs that essentially expunge your record if you get arrested, charged, and plead guilty or are convicted in court. You serve your sentence, and as long as you stay out of trouble, it sort of disappears as part of it. But it's a non-serious crime. All right, so after, any questions about the prosecutor's discretion and informal charge? All right, so the judge is the primary decision maker in the initial appearance. The jail decision is most important. In terms of the informal charge decision, the prosecutor is the only person that makes the decision. Nobody else gives input into that. They'll talk to the police, they'll look at the evidence, but it's really the prosecutor that makes the decision. So that's an informal charge decision that happens in their office. It doesn't happen in a courtroom. It happens, they look at the evidence and they make their decision. If they decide to charge the person, and that 50% of the time they say, okay, this person, we have a pretty good case, we're going to charge this person, then we got to make a formal charge decision, which is the next step of the process. So prosecutors decided to charge this person. This has to be formally addressed within a court. Counties use two different types of formal charge procedures. They either use a grand jury hearing or they use a preliminary hearing. At the end of the day, they both lead to formal charges in a particular case or a person being released. But both of these types of formal charge processes, the goal is to hold the prosecutor accountable. That is, make sure the prosecutor isn't processing a case that is not winnable. So let me talk about each of the two different types of formal charge procedures. We talked at great length about the grand jury earlier in the semester, but a grand jury hearing is just that. It is members of the community who come and serve, okay? Really important to know the number of grand jury members. It is usually 23 people that come and hear the evidence. So there's two types of grand jury hearings. We talked about the investigatory grand jury. These are rare, all right? Investigatory grand jury hearings are rare. This is where you bring people together in the public to conduct an investigation. Remember, we talked about this. Prosecutors can conduct independent investigations without involving the police at all. And they can do things to investigate the police department. Essentially what a prosecutor does, their investigatory arm, is call in 23 members of the public and they present evidence. And so they put people on the stand. Those people don't have attorneys. There's not a defense attorney over here questioning witnesses. It's the prosecutor putting a witness on the stand, asking them questions, next witness. The really interesting thing about grand jury hearings, or one of the really interesting things, is that the members of the grand jury can sit there and ask questions. So the prosecutor will ask questions of the particular individual. When the prosecution's done, they'll ask, does any grand jury member have any questions? And so somebody can say, whatever question, the prosecution wasn't clear on something, if they have some concern about something, they can ask the question of the individual, and then there's a dialogue that occurs. And so what the purpose of the investigatory is an independent investigation that the prosecution can hold, and then at the end of that, right, they'll decide, there's 23 people, whether or not there's enough evidence to indict anybody in terms of moving things forward or asking for more evidence. Those are rare. They happen rarely, but a prosecutor can call an investigatory. The vast majority of grand jury hearings that occur are accusatory grand jury. All this is, don't be misled by the name. An accusatory grand jury is, all it does is decide whether or not the individuals, the 23 individuals, agree or disagree with the prosecutor's decision to charge. So it's essentially a hearing to validate the informal charge decision. So the prosecution looks at all the evidence that the police they have at that particular point in time, right? The police testimony, the physical evidence, victim testimony, witness testimony, look at all of that, and they decide to charge the person with 3 counts of robbery, serious violent crime, right? What happens in the grand jury hearing then is that the prosecution has to convince those 23 people, at least the majority, that they have enough evidence to prove guilt beyond a reasonable doubt for those 3 counts of robbery. And so they have to present enough of their case in court to prove that. So they'll call a police officer, perhaps. They'll call maybe a victim, or they may call a couple witnesses, or even they may call some experts in order to prove those different things, all right? Now, look, a grand jury hearing is just the prosecutor. It's only for the prosecutor to present evidence. There's no cross-examination of witnesses, right? And the defense does not present any evidence at all. And what's interesting about a grand jury is the defendant doesn't even have a right to be there. All right? They can be there, but the defendant does not have a right to be at the grand jury hearing. So it's really just a check on prosecutorial discretion. And so the prosecution gets to put their best foot forward. They present enough evidence to convince at least half of 23, so at least 12 of those people who have been called in to serve that they have enough evidence to move the case forward. Right? They're not asked to prove guilt beyond a reasonable doubt, just enough that this person should be indicted. Right? And so if the prosecutor doesn't convince them that this person committed 3 robberies, they may come back and say, well, we think there's enough evidence to prove 2 robberies. Right? So we'll charge 2 counts of robbery in this particular case. A Again, the prosecutor can go back, collect more evidence, bring another grand jury in, and do it all over again to get the third count, if they think that they have a case. So all it is that the grand jury deciding by majority vote that this person should be indicted. All right. An interesting thing, or one of the many interesting things of grand juries, are number one, they're private and secret. There's two types of court hearings you can't go to if you're interested. Like I said, you should go to a county courthouse. For the summer, when you have a free day, you're not doing anything, you should go to your county courthouse and then just randomly go to any trials. You'll be surprised at some of the interesting things you may see. Two different court rooms you'll be kicked out of. If it's a juvenile case, you'll be kicked out. Juvenile court cases are private. You have no access to them. News media doesn't have any access to them. They're closed courtrooms. You're not allowed in those courts. And the bailiff will ask you to leave to go in. The other thing that is secret are grand jury hearings. Public cannot access grand jury hearings. The proceedings of grand jury hearings are also secret in terms of decision. The only thing that we get from a grand jury, all the evidence that may be presented during that day, the only thing you get is the indictment and what's listed in the indictment. And the only thing that the indictment lists are what the person is charged with and their count. All right? Questions about grand jury?
Does the prosecution ever drop a case because of reception during a grand jury hearing?
Absolutely. Their influence strong. I mean, if you can't, look, if a prosecutor goes in and can't convince only 12 out of 23 people that they have a strong enough case and that they're asking tough questions of their case, the prosecution, if they're smart, is going to say, look, I got some problems. I mean, if I can't prove, I'm not proving guilt beyond a reasonable doubt. I'm just proving that there's enough evidence to charge. If I don't get there here, the prosecutor is probably going to pull back and change their mind about their case or really start all over and say, I got to go get more evidence. So grand juries can be really influential if that happens. Usually, though, the prosecution's smart. Prosecutors is going to put their best foot forward, right, to make it really easy for the grand jury to say, yeah, this person looks like they really did it. Even though the prosecution knows that there's problems with their case, they're not obligated to present those problems. Those problems are going to come up at trial or later on in the process. And so it's really biased. There's Tom Wolfe, who's written a lot of books, including books about the criminal justice system. He wrote a book a long time ago called The Bonfire of Vanity, which is about criminal justice in New York City, which is a service in every meaning of the word service. But he talked about the grand jury process and said grand juries can be convinced to indict a ham sandwich, which is probably true. Because the prosecutor really controls it. So important things to remember here for grand jury: 23 people, right? It's a majority vote, so you don't have to convince every one of them, just half, one more than half. And then the result of the grand jury hearing is an indictment. These are time consuming. You can imagine pulling 23 people in from the community and having a lot of these grand jury hearings. It's costly, it's time consuming. And so because of that, a lot of jurisdictions have moved to another formal charge procedure hearing, and that's the preliminary hearing. Preliminary hearing, the biggest difference is grand jury hearing is before members of the public, preliminary hearings are before a judge. The judge decides whether or not there's enough evidence. Everything else is pretty similar. That is, the prosecution is just presenting their case, although in preliminary hearings, the defendant has the right to be there. Grand jury hearing, they do not. So the defendant has the right to be there, but they still don't get to cross-examine. With preliminary hearings, they're still not presenting evidence. They get to at least hear what the prosecution is considering the best foot forward, right? And so that, again, the prosecution presents enough evidence to convince the judge that this person should be formally charged. Not guilty beyond a reasonable doubt. The judge is going to ask tough questions. Just like a grand jury can ask questions, a judge is going to ask questions about the case. If there are holes in the case, the judge is going to ask the prosecutor and say, wait a minute, this really didn't, you're not convincing me. Give me more evidence. Give me more facts. Or he'll ask the judge, he or she may ask questions of the witnesses in terms of, they may ask questions of the police officer, just to make sure. And if the judge agrees with the prosecutor's informal decision, what we get filed here is an information. All right? The grand jury leads to indictment, preliminary hearing leads to information. Great.
Is there any data on like how likely you are to get convicted based on whether or not you were in a preliminary hearing or a grand jury hearing?
No, I mean, there's not much research on this part of the system. I would say this though, that either or, right? Our system does a really good job of kicking out bad cases early before we get here. Prosecutors' discretion, pushing out 50% of cases at the informal charge procedure is a really important step in the process. They're really getting rid of difficult cases for them. If they charge a person as we get here, then it's a strong case already. And so there's usually going to be a conviction most of the time. All right. The other thing that happens now, let me go back for a second. So, preliminary hearing, grand jury hearing, it's the formal charge decision. If it's a grand jury hearing, it's indictment, and then if it's a preliminary hearing, it's information that takes us to the next stage. It takes us to an arraignment. So the arraignment is importantly, first, the defendant is informed of specific charges. Remember, you're arrested. Police officers don't have to tell you why you're being arrested, right? There's an informal charge procedure. Prosecutors look at the evidence, decide what the person's going to be charged with. And then there's a formal charging process where a grand jury or a judge decides what they approve of, right? By this particular point in time, you have no idea what you're being charged with in the number of counts, right? And so one of the first steps that happens at the arraignment is decide, what you've been charged with. So this is what you need to know, right? You've been charged with 4 counts of burglary on this particular date, or 7 counts of robbery, or 2 counts of auto theft, or whatever it might be. The second thing that happens at the arraignment is you're asked to enter a plea. This is a really important part of this. The most important, the most frequent type of plea made at arraignment is not guilty. Remember, you have not had any opportunity to push back on the prosecution's case. You haven't had an opportunity to present witnesses, cross-examine their witnesses, say anything about your side of the story. So at the very early stages of the court process, you're going to plead guilty. Now, just like we talked about last week, at some point in the next couple months, you'll change your plea probably to plead guilty, right? But at this point in the court process, the vast majority of defendants, almost all defendants, plead not guilty. But they can plead guilty, which we talked about, right? And what that means, and all the reasons why people do it, what value it is for a defendant, what value it is to the system. You can plead no contest. No contest plea is important to know. A no contest plea is, I am pleading guilty, all right? But I'm not admitting guilt. So what you're asking to do is treat me like I just pled guilty. Sentence me like I just pled guilty. But this is not an admission of guilt. It happens rarely. The only reason why somebody might plead no contest is they're fearful that the victim may sue them for a variety of different reasons, right? And so remember, the standard of proof in civil cases is different than the standard of proof in criminal cases. And so if you plead guilty, then there's a strong civil case against you. If you plead no contest, the person who sues you still has to prove that you in fact did X or Y before they get damages.
So I don't know if this just falls under like guilty completely, but like when I got in a car accident, they made me say like in front of the judge, like guilty, not guilty, or guilty with an explanation. And then they like lowered whatever like charge I had originally or whatever, and like, I don't know, gave me ways to not get points. So like guilty with an explanation be under guilty or like no contest?
It would be under guilty.
Okay.
It's the same thing. They do give you, pleading guilty is typically, you're hoping to say, was it traffic court, or was it?
I think I like, drove off a highway in the road sign on accident, and they said it was like bad at first. Like they charged me for like reckless driving or something, or like I don't know. But they lowered it to impeding traffic, so I think it was traffic.
Sure, yeah. So in that, so the guilty with explanation is just something, giving your voice, so you can say, you know, what actually happened. Hoping, whether or not it influences the judge's decision or not. Most research would say if you did plead guilty or guilty with explanation, there's not much difference in what the ultimate sentence is. But people feel really good about the fact that they got to say, it's like, look, okay, I did it. But you're saying that I drove, you know, recklessly. I really did it, you know? And this is why it happened, you know, slippery, right off, whatever it might be. And so even though it may not, you're still gonna get a similar sentence by pleading guilty, but at least feel better about it. So, yeah. And so the last thing that you can plead is the insanity plea. Again, we talked a little bit about this earlier in the semester, but it's really important to note that insanity is rarely ever anymore. It's rarely used as a plea in courts anymore. There's a couple of reasons for that. Number one is it's not really helpful because most of any social support for helping people with mental illness in our society a lot of it has disappeared. And so most people would say if there is mental illness as part of the issue, they're better off staying within the criminal justice system because then they will be put into services that might help them and help them through that process. And the other thing is that it's a really difficult legal thing to prove. We talked about the different rules about, you know, whether or not a person can, the different types of the Durham rule, we talked about the McNaughton rule and other things earlier. You still have to prove that this person was in fact insane. And remember, if you are found not guilty by reason of insanity, it means that the only way you're still going to be punished in the civil commitment system, and the only way to get out is to prove that you are no longer insane. So if you commit a relatively, even a non-violent crime like burglary, right, but you plead not guilty by insanity, and you're found not guilty by insanity by a jury, that means that you could be civilly committed for the rest of your life, according to prove yourself insane. And so most people decide not to. So it's rarely used in terms of it. A number of states have an exception or a kind of a way to deal with that is they have guilty but mentally ill statutes. And so you plead guilty, but you also have, with guilty but mentally ill, is that the sentence might be different. You take that into account in terms of your punishment and how that case is handled. All right, questions about any of the 4 different types of pleas? All right, so an arraignment, remember, the vast majority of defendants plead number 1, plead not guilty this time. Later on, they're going to change their plea to something else. All right, so an arraignment, one other thing, informs defendants of their specific charges, enters the plea, and then we set the trial date. I'll get through one more step. It's a pretty straightforward step, but it's an important one. So again, we're at the arraignment. The person has just been told what they've been charged with. They've entered the plea of not guilty. and then they set a trial date for usually about 6 months to 8 months, depending how busy the court is. It could be a year and a half. Whatever their trial date is, they put that on the calendar and say, okay, we'll have your trial on March, late March, August 1st, 2024. Now, what happens in between the arraignment and trial are motions. And the number of motion hearings are, there is no set number. You can raise as many motions as you want. So I'm going to talk about different types of motions. First off, what is a motion? A motion is really a mini trial. Essentially what they are tools for the defense to make their case stronger. Remember, at no point up until now has the defense had an opportunity to question the strength of the prosecution's case. Right? It's the prosecutor making an informal charge decision. It's the prosecutor presenting evidence to a grand jury or a preliminary hearing. Right? There's really no evidence presented at an arraignment. It's just this person making a plea. Right? And so all those steps are prosecutorial focus. Here, though, with motion hearings, is an opportunity for the defense attorney to start whittling away at the strength of the prosecutor's case. And so they do that by having these mini trials where they'll take a part of the prosecution's case and start presenting evidence to show that their case isn't as strong as they thought it was. All right? So there's a number of different types of motions you can have. These are sort of legal filings that the defense says to look at the evidence. And then there's a trial that's held. So if you file a motion to change venue, the prosecution will come in and say, I don't want to change venue. These are the reasons why. They'll present evidence. They'll present witnesses to make a case. And then the defense will present a case why they should change venue. And then the judge makes a decision whether or not we should change venue. All right? So change of venue, remember we talked a little bit about this. This is cases with high publicity, when there's a lot of news coverage or a lot of publicity or a lot of people are talking about the case, right? If you're the defendant and if that publicity is negative for you as a defendant, you do not want a jury of your peers, the people from that community to come in who already know a lot about you, already know a lot about the case. If it's a particularly horrific case, you're going to ask to take that case and move it to another county, someplace else where people may not know you, may not know the strength of your case, may not know what you do. So you make a motion to change venue, which moves the case from where you got arrested, Ingham County, and moves it to another county that's willing to take it 3 hours away, 4 hours away, 2 hours away. And at that other place, in that other county is where the prosecution will present their case, the defense will present their case. But likely, those people may not know as much about the case as the county where it happened. All right. Motions for discovery. Remember that we talked about this. Prosecutors have to give every part of their case to the defense. Sometimes they don't, and so they may actually have court hearings to make sure that they do this. Now, two really important motions. One is the motion to suppress evidence. This is the Fourth Amendment motion. All right, today we talked about whether or not, right, the strength of a case is really based on the evidence and the physical evidence that they have. And so what the defense attorney is going to try to do is show that they didn't have reasonable suspicion, or they didn't have police didn't have probable cause, or they should have got a warrant before they collected that evidence, that the person didn't consent. So again, the prosecutor has to present probably the police officer or police officers in terms of the case, look at the warrant, the defense will present, and be able to cross-examine those witnesses to try to get that piece of evidence thrown out. If the judge rules in favor of the defendant, that piece of evidence disappears, right? The prosecution can't use it at trial. So by removing that piece of evidence, the prosecution might decide to just not move forward with the case. Or they can say, well, I still got enough evidence to make a conviction, whatever it is. So the suppression of evidence is probably the most common type of motion hearing that we get, is because it really increases the strength or improves the strength of the defendant's case. Another very common type of motion is continuance, all right? Most defendants want to take their time. They want time. Time is their friend in court. You don't want to get it over with quick. The hope is that, you know, your case gets strengthened because a police officer dies, or a witness dies, or they forget, you know. I mean, 6 months, you remember what happened 8 months ago? Well, the more time that happens, the more likely that your memory starts to fade about what actually occurred. So most defendants want to give up their right to have a speedy trial. Right? You do have a right as a defendant in many jurisdictions to a speedy trial. That the general rule, the Federal Speedy Trial Act, is that the systems, all these steps that we're talking about, from the time you're arrested, you have to be indicted within 30 days after you're indicted. All right? After you're indicted, you have 10 days to be arraigned. And then from arraignment to get to trial, you have 60 days. So all told, what's supposed to happen in our criminal justice system is from arrest, the system has 100 days, adding the 30, 10, to 60, to get to trial, have your trial. That's only 3 months. But when I'm telling you that the average is 6 to 8 months in most jurisdictions and even longer, it's because most defendants give up this right. Right? They're willing to give up this right to a speedy trial. They want to continue. They want to wait. Not these parts, but this 60 days, they want to keep pushing the trial back. They want to keep pushing the trial back, keep pushing the trial back. And so they're willing to wait. So there's a 100-day requirement from arrest to trial, but commonly it is given up with the interest of improving your case. Have a good day. See y'all next week. Have a good week.